Hey, welcome to Spin Legal on March 27th, 2024, brought to you by Angela Browne and Peter Giblett of Invictus Legal LLP. Tonight we're discussing what to do if you're accused of a crime by the police. Good evening, Angela. How are you?
Oh, pretty good. How are you doing, Peter?
I'm doing good. I'm doing good today. So, just a reminder: Spin Legal provides legal discussion about legal topics on a current interest basis each week. So tonight we're going to cover the question about what to do if you're accused of a crime by the police.
Okay.
So that's an important question there. So you've just been accused of a crime. What should you do?
Okay. That can come to you in a number of ways. Okay. Like you could be supposedly caught doing the crime, where a police officer would catch up to you and put you under arrest. Okay. Like maybe they thought that you were dealing drugs or something, or you may have been in the middle of a fight with someone, or something has been shortly happened, and he caught you while happening. And or they can go after you later on with a summons if they have reasonable grounds to believe that you had committed a crime within 6 months. That's I believe that they still have the 6 month timeline for the summary offenses. For indictable, it's much longer. For some, they might even not have a statute of limitation, depending on the type of crime and the
Murder,
seriousness.
like murder, doesn't have a statute of limitations. I believe rape doesn't either, does it?
Yeah. Like the thing is, you could commit something like 40 years ago. There was somebody in Toronto recently who was found to have committed a crime. He's murdered two women in Toronto during the 80s. And
Yeah,
recently he was brought to court and he was put in jail.
yeah. And those sort of crimes, those most heinous crimes, are exactly the sort of crimes we wish to ensure people are, held responsible for,
Yep.
no matter how long they've gotten away with it.
Yep. This is the most serious of all crimes that people have, and they would have a longer statute of limitations. And for the summary conviction, you just go out, they would go out and they would try to they suspect that you've been involved. And what generally happens if you're arrested and then they take you become in a police car, they would say you're arrested for assault or whatever. And to caution you, a police officer sometimes tells you you have a right to remain silent. You have a right to do things. Do not talk to me. Sometimes a police officer will try to get you talking, and it's not always a good idea to say anything to the police officer, right? Because like after you're arrested and they know what charge it is, like find out what charge that you're being arrested on, right? And then that's it, right? And they also tell you that you also have a right to consult with counsel. And then if you don't have the money for a lawyer, they also have a right to say, okay, we can send you to duty counsel and also help you apply for legal aid. Or if you know
So,
somebody who is a lawyer, they can contact the person for
yeah,
you to come and see you.
yeah.
This has happened.
So a duty counsel, are they going to come along in the next 15 minutes?
Generally, no, but sometimes they'll talk to you on the phone. So if you're put inside if you're brought to a police station and they put you in a room by yourself, so they allow you to talk on the phone. They don't listen in. You're allowed to talk to a lawyer, and you're allowed to have that without someone listening in because your communications between a lawyer or your paralegal, if it's a crime that a paralegal can assist you with, these communications are confidential, and police cannot be listening in on them.
Okay, what does it mean, therefore, to be cautioned and arrested?
Cautioned to tell you, okay, you're to say not to say anything further, or if you do say something, or if you start to disclose things, the police officer may want to caution you about the issues that you're trying to discuss, especially if it may lead to something that may be used against you. And arrested is they stop you. They stop you from where you're going, and they're allowed to detain you. Okay. The police cannot just detain you, but not on a charge. They have, like, if they're not going to charge you with anything, they have to let you go.
Yeah.
Okay?
So if you're just walking down the street and they notice you, oh, that Angela lady, I know her. She's the monster who did X back then. But they got not got an arrest warrant for you. They can't pick. Can they pick you up?
No, they can stop me and ask me what I'm doing, but I don't have to say anything to them. But if they're suspicious of something, like say for instance, I just happened to be in the same place where a robbery had just taken
Yeah.
place, and somebody at the scene of the robbery described me exactly to a T. Yeah, they have a right to start asking questions. And if they have what they call reasonable grounds has been interpreted and reinterpreted through the courts for many years. If
Yeah.
they have these reasonable grounds, then they could arrest me.
But again, those descriptions are somewhat vague anyway, aren't they? And
Yes.
just using the attributes of your physical appearance,
Hmm.
you
And it
know,
has to be beyond a mere suspicion.
yeah.
It can't be
And
just say, I'm suspicious of this Peter there. This Peter looks like, well, he's British, and somebody said that the guy had a British accent. Okay, there's a lot of people with a British accent.
well, I was going to say, and again, an older lady with ginger hair. But the fact of the matter is that the crime happened like, half a mile in that direction, and you just came out the building here and started walking in that direction,
Yeah.
ironically away from where the crime occurred,
Yeah.
and you were picked up literally across the street from where you exited your office. As you started to walk down the street, the police saw you and went, she looks suspicious.
Yeah. So they decide it has to be beyond a mere suspicion. Okay, there has to be something there that would bring a reason for them to detain me and not somebody else with red hair and who looks about my age. So there, and the
And
police
again,
are trained in this.
and again, that's an awkward one, isn't it? Because
Yeah.
saying, oh, she's a white red-haired lady, probably, let's say, just to throw some things out there, white red-haired lady, she's in her mid 30s to maybe early 40s. And the person looks at you and goes, yeah, that's about right. She's a little bit disheveled, she's got a darker coat on. And hey, if you're just coming out of the office having just had a really dog awful day and you kind of go, I just want to get home, right? Yeah,
Mm-hmm.
you might look the part.
Mm-hmm.
But then they miss the other thing, which is slim.
Yeah.
Slim, 5'2".
Okay, so that's something that we're in separate rooms, and I can't do anything about Peter.
Yeah, but you know why I'm saying. So sometimes these descriptions miss things you wouldn't know.
Yeah. That's like what they say, like they're talking about some guy, he's got brown hair, he's got blue eyes, and he's white, he has a black coat, black running shoes. Okay, that could describe a million men in Toronto.
That's the problem. That is the problem, isn't it?
Yeah.
Okay. So that's
So basically, when they stop you, they have to have beyond a mere suspicion.
Yeah.
So there's suspicion, but that's not enough. They have to have something more than that.
Yeah. They can't just say she looks shady.
Yeah, exactly. Yeah, and this is sometimes where some things get racialized, where they used to assume that, like, especially if someone says, "Oh, it was a black man, he came and robbed me." Oh yeah, that's really descriptive.
Yeah. He's a black man,
and it can be and it could cause a
exactly.
racial profiling.
Absolutely, and that's absolutely right. That's an absolute problem because you go to certain parts, of, let's say, Toronto, and there might well be a dozen black men with it. Just turn your head this way, there's a dozen. Turn your head this way, there's a dozen. Look straight ahead, there's another dozen.
Yeah, and absolutely none of
doesn't
them
mean a thing
for the crime that you're looking for.
Yes.
Yeah.
Doesn't mean a thing. Yeah.
Yeah, exactly.
That's
This is where police officers, although they have some discretion, but they're being trained where they have to be careful when they exercise this discretion.
Yeah.
Okay? So they're not being profiling particular types of people.
Yeah.
Okay? Like you start profiling legal professionals, that's when it gets to be a problem.
Okay, so moving on. So you're at home and the police knock on the door and they produce a summons. What do you do?
Then you look at the summons, it'll have a court date involved, usually. Okay, if it's usually this is when it's a summons for a summary conviction offense. It's sometimes what happened is you got a fight in a bar, but you left before the police arrived. But somebody identified you and they know who you are, so the police will find you because I don't know how they find people, but I think they can find you through different databases that they have.
Well, they can presumably look you up on things like identification databases and the like that they have access to that the average citizen does not.
Yeah, exactly. They have whole lot of tools that even a private investigator doesn't have.
And
so
in
they
fact,
can find you and they'll knock on your door and say, hey, Miss Browne, oh, Mr. Giblett, they said you're charged with shoplifting at Loblaws. Like I know you went to Loblaws and I know they're robbing people, but that's okay. But you're charged with shoplifting from them. So here's a summons. Your court date is going to be April 3rd.
But again, okay, so your summons there, essentially, the police are handing you a sheet of paper, right?
Mm-hmm.
Handing you a sheet of paper, and that basically means you can just say, hey, thank you very much, close the door behind you and walk away and watch TV again, right?
It is a charging document. The police have to go to a justice of the peace and they have to lay an information about you, and they have to explain why they believe that Peter Giblett is at fault for this particular offense, what happened, when, and so forth. And then they have to write it all out, and they have to swear it before, and then go before that and have it signed, and then they go find you, and then they serve you with it, because there's a court date involved with it. So you have to go, and that's your first day of court, which is your first day of appearance.
Yeah, and I would also say one thing about if the police come to your door and produce a summons, just be polite to them. Be matter of fact. Identify yourself, because that is actually one of the things they will require of you. You know, you can identify yourself as Joe Blow at 16 Maple Crescent, because they know it's 16 Maple Crescent because they just knocked on the door.
And they also know that's you, because if you got a driver's license, they can look it up and they can see you. Even if you got a photo card, they can look it up.
Yeah.
They know exactly what you look like.
Yeah, and you may, of course, be required to produce said ID.
Yeah, exactly. Yeah. And this is very important because what they want to do is they want to make sure that they're giving the summons to the correct person.
Yeah.
That correct person knows that they have to go to court.
Okay, so further question that I think needs to be asked here. So, of course, I don't have my wallet on me because I'm sitting in my lounge. Can I close and lock the door and go in and get my wallet in order that I can produce my ID for the police?
I think sometimes they don't let you do that. I think sometimes they would want to maybe keep the door there ajar while you're doing this, because they don't want you running out the back door going somewhere.
that is exactly, of course, why I asked that question. Because of course,
and it happens. There are people who are scoundrels. They will do that.
Yeah. Oh, of course there are. But so what we're basically saying here is we recommend, of course, that you have, good behavior, that you don't go running out the back door.
Cooperation with the police goes a far way when you're involved in those situations, because you don't want to be remembered by the police as the person who ran out the back door, who tried to lie about who their ID was, all that stuff. You don't want to be remembered that way.
Hey, if I ran out the back door and I tried to jump over the fence, I might be able to get up and hold on to the back fence, but I'm not going to be able to pull myself and climb over it.
Yeah,
Because
exactly.
it's 8
They'll
foot
get
high,
after you. They'll find you.
and they'll pull me down. They'll pull me down before I'm
Yeah.
even halfway up, right?
Yeah, and they
So,
may even
yeah,
try to go after you for resisting or something.
yeah, exactly.
Yeah,
So that can
and yeah,
make things worse.
yeah,
Okay, so
exactly. When you're
we've used
cooperative, they know this. You got a summons, and they may have some conditions on the bottom. Don't talk to whoever it is that you allegedly beat up, hey, or whatever. Then
don't talk to
and they may
Angela
even
Brown.
have a date where you might have to
Yeah.
go to the police station to have your fingerprints.
Yeah,
Okay?
don't talk to Angela Brown. Stay more than 150 meters away from Angela Brown. Do not attend the offices at 71 King Street. What? I can't go to work. No. Okay.
Yeah.
Nothing's like yes, that can happen, of course.
Yeah.
In
And
a
then there's
workplace.
also a thing where you might have to go to the police station to have your fingerprints taken,
Yeah.
and to be booked, like legally booked. Because
Yeah.
what they do is they do this to record you as being charged with an offense, and they have you on record for that.
And they
And
can put conditions. They can put
and then they
conditions
can put
on
conditions.
on
They
the
can put
summer.
conditions on your release.
Yeah, on the
Okay?
summons, which basically might even include, let's say you were accused of beating up your neighboring tenant in your apartment building. Well, since you're now under a clause that says you must keep 150 meters away from them, and they live right next door to you, well, you can't go home, can you?
Nope, you might have to stay with a relative or a friend or
Yeah.
something.
Yeah.
So these are things where a lot of times that things like that happen. Okay, and this is very important. A lot of times people get these things, and then they come into my office. They show me this summons, but Angela, I didn't do this. Okay, and I said, okay, that's fine. Okay, I don't tell them, to say, okay, are you guilty or not guilty? I don't get into that discussion with them.
Yeah.
What we do is we just guide them through the process. We want
Yeah.
to make sure that, first of all, that their rights are recognized, that once it goes to the first appearance in court, we try to obtain what's called a screening document. Okay, we need to go on to the next topic here.
Yeah. Well, I was going to say we kind of jumped ahead, so let's
I
go
know
on
we're
to the
jumping
next
ahead all
topic.
the time.
Let's
Okay,
go on to the next topic. We've used two terms here: indictable and summary offences.
Yeah.
Two different paragraphs. So let's tell our audience what's the difference between an indictable offence and a summary offence.
Yeah, a summary conviction offense is any offense that's subject to a conviction of less than 2 years less a day. A provincial offense, they usually call it, through a provincial court. An indictable offense is anything over that, which would be a conviction that would be charged under
Okay,
that.
so we just looked up one today where the section of the criminal code stated that as an indictable offence it has a maximum of 5 years, and as a summary offence has a maximum of 2 years minus a day. What does that mean? Tell the audience what that means.
Okay, what that means is basically that's called a hybrid offense. Okay, when this is where a crown attorney gets to elect. Okay, so many of these offenses where the crown attorney can elect to go summary, or they can go indictable. Okay, so if something was done, like say assault with a weapon, and it seemed like a pretty serious offense, like the guy took a baseball bat and beat somebody up in the head or something, that's a serious thing. So they may proceed by indictment. Or they can do a summary offense. Oh, somebody just picked up a cup of coffee and they threw it at them, okay, which may be a summary offense. The Crown has the absolute right to choose how they are going to elect. That election cannot be appealed.
Okay, and it's an important topic. Okay, but anyway, so I've just been picked up on one of those offences, and I ring up Invictus Legal and I say, hey, can I speak with Angela Browne? And Angela takes my case, And then she calls up the prosecutor and asks the question, are you likely to be pursuing this as indictable or as summary? Now, knowing that you're a paralegal and knowing that she's lost 3 times before to you, she might really put you in a bad light and say, no, we're going indictable.
They may, and I've heard that this happen, but I'm hoping that they don't do this, because this doesn't reflect well on the prosecutor's plight of ethics, because the role of the prosecutor is not to gain a conviction. The role of the prosecutor is to ensure that justice is done. I've met many prosecutors who kind of look at something and they take a second look at the evidence and they decide to withdraw because they decide that they don't have enough to proceed. Okay. So there's many different things. So the prosecutor has to decide in the best interest, but based on the information they have, how they're going to proceed. Okay. And many times what I generally do is I wait till they bring it into the court. And then they have what's called a screening sheet. A screening sheet is usually given at the first appearance. And on the screening sheet, it indicates the election, whether it is proceeding by indictment or proceeding by summary. When it is a summary case, most of these summary offense cases, paralegals have been handling them. There's actually a whole list of these summary conviction offenses that I have in a book that I have here where paralegals are able to represent people. And this is something that has been going on for years where paralegals have been allowed to do this. So at that time, once you know that it's selected summary and it's a defense that we could represent the person in, then what we do is the first thing we do is then we just handle our first appearance. And first appearance basically is that's where you gather all your disclosure, your screening. You have a chance to get to know who the Crown is, who is going to be handling that case on behalf of the prosecution. Okay? So this is very time when paralegals start to get to know who is going to be in charge of that case. And if you are somebody who likes to do this as a frequent thing, get to know some of these Crown prosecutors, talk to them, because it's very important to develop a relationship.
Yeah, obviously the lawyers and the paralegals in Ontario will get, if they're dealing with criminal matters all the time, they will deal with the prosecutors because they'll and actually the fact that they deal with prosecutors all the time is a good thing. Don't ever believe that they are on the prosecutor's side. No, they are firmly on your side. But the point being is that if they can have a one-to-one discussion with the prosecutor that's sane, that doesn't involve the emotion that maybe the indicted person or the accused person may have, because I'm not guilty, right? So the paralegal or lawyer can actually sit down and say, Angela, what are the options here? My client believes he's not guilty. On the 1st of March, he wasn't in Montebello Park. He was in Niagara Falls. Yeah.
I'll say, yeah, he wasn't even in the country. Here's a copy of those plane tickets.
Yeah.
And he was out in Acapulco.
Yeah. Yeah, exactly, that type of thing.
Yeah.
And then we're into the situation where you're essentially negotiating at that point.
Yeah, we negotiate. We talk about what happened, we talk about the disclosure, and then what I do is I take the disclosure back and I review it. Okay. And I look for things in the disclosure, and then I talk to the client about what they think about some of the allegations that the Crown is making.
All right, let's step back a minute and go to our next question, which our next question is, what happens if the police take them to the police station? What are your rights?
Yeah, the police may take you. If you get arrested, the police may take you to the police station because they want to book you right away and then put you in the system, take your fingerprints. They don't do it like they used to. You don't put on a scan of you don't go on an ink pad or whatever anymore. You go on actually what looks like an electronic pad and they take your fingerprints. Then it gets put into some kind of system. federally.
If you've ever been to the USA, they've got a fingerprint pad in the immigration, which basically you put your fingers on a pad like
Yeah.
that, and you
Yeah.
put your thumb on a pad in the same
Yeah.
way, and it's
Yeah.
essentially that these days.
Yeah, and they can
You're
actually
not
see.
walking away with black fingers.
Nope, nope. It's all electronic these days, biometric.
Yeah.
Okay, so what they do is they do that, and after you're through, they talk to you about what you're charged with. Okay, they explain all the different charges, and they may even have some documents for you. In some cases, the charge is not that serious. You're right. You were at a protest, and you might have knocked something over, or you might have broke a window or something, or you might have got somebody upset because a lot of screaming and yelling at a protest, and you're offensive. Or you might have been, I don't know. There's a lot of different reasons.
Drunken disorderlies at
Drunken
Charters
disorderly.
on a Friday night.
Yeah,
Yeah,
exactly.
and
So what they might do is say, okay, Mr. Giblett, we realize that this is your first time, and I don't see anything else in your priors. So why don't we just have you just go home, and then you can come back to court at this such and such a date. They let you out what they call out on your own recognizance. Okay, some people say they're letting me out on my ROR. They call it.
yeah,
Okay,
I was
letting
going
you
to
out on
say
your own recognizance. Yeah.
that's exactly the thing that has been. So here's the question. So when they arrest you, what do the police have to say to you?
It says you're under arrest and you're being charged with whatever the charge is. Okay, and they could handcuff you. Okay, you might be asked to put your hands behind your back to handcuff you, and they can until they take you to the car, and then when you're at the police station, then they release you, and then they start to book you. And many times, if they don't let you out on your ROR, they could keep you. Okay, and yes, they can keep you detained.
And
Okay, and
before
generally, you have a reasonable right to bail. Okay, you have a right to a bail hearing, and you have a certain amount of time a bail hearing
But
has to be held.
let's stop you there, Angela. We'll get onto the bail
Okay,
hearing,
okay.
release and bail hearings, etc. Got a very important question, which we should not here in Canada get confused with. So, what are Miranda rights?
Miranda rights. Okay, this is where
This
people watch
comes
too
from,
much American television.
yeah, because it comes from a case of, I believe, California versus Miranda, doesn't it?
Yeah, exactly. Hey, this is where they
Back
did
in
not.
1960 something.
Yeah,
Yeah.
yeah. Somebody starts mentioning that I need a lawyer, and they have to cease questioning in the States. In Canada, they don't care. Okay, but you also have a right to remain silent the same way they do in the States. But you also have a right to ask for counsel and instruct counsel without delay. Right? So it's very different in the States.
Okay, so again, right to instruct counsel. So hey, so hey, here's the situation. I'm sorry, I need my cell phone. You take my cell phone. I've got my lawyer's number on there. So I'm going to call my lawyer. Hey, Joe. I need to be. I've been arrested for this. I need somebody to get me out.
Yeah. You
Right?
can call your lawyer. You're allowed to talk to somebody. They do put you in. You say, I want to talk to somebody on the phone. Sometimes they'll provide you with a room with a phone in it, or you can use your cell phone if they allow you to keep it. Sometimes your offense involves a cell phone, like especially if you're articulating threats to people by text messages or something.
Well, I would think that most of the time they would take your cell phone off of
Yeah,
you.
they would want to know things if
But
there's something there.
particularly if you were accused of a crime that involved a conspiracy with other people.
Yeah, exactly. Yeah, that's what they did when I knew someone else who was charged with threatening people, and the texts were very clear. I was going to do this. I was going to shoot this person and shoot that person, and got my gun in the mail and all that stuff. Never put that stuff on a cell phone. Never put that in a text message.
And certainly don't put that in social media, right?
Yes, exactly. It's very, very, But but they will give you a way to call people, so you can get it. They'll give you a phone number, like a phone book or some kind of way to get a hold of your lawyer if you don't know their number by heart.
Okay. So
So
next,
they can tell,
very
or you can
important.
talk to duty counsel if you don't know a lawyer.
Yeah. So your next important question is: you've been in the police station now for 5 hours. Will the police release you?
As I said, we discussed the ROR option, release on own recognizance, which they will release you and they'll give you paperwork to go, which has conditions and a court date for you.
Mm-hmm.
Or they would just, or they would keep you and hold you for a bit until there is a bail hearing, and they would,
Okay.
yeah.
Okay. You've just given me my court date. I've got a problem with this court date, Mr. Police Officer.
Hmm.
I've got an operation. I've got my knee operation on this date.
It's too bad. You got to go there either by yourself or through counsel. You got to show up. Okay, so if you can't go there on that date, a counsel, you can get a lawyer to show up on your place, and they can get, what did they call that? Where they get the dispensation to speak on your behalf. They could do that.
Yeah. Okay. All right. Okay. So, okay, you've been arrested. You're in the police cells. How do you get a legal representative?
Well, sometimes you just call duty counsel, say, hey, duty counsel, what do I do? What are my next steps? Okay. The first thing they'll tell you is don't say anything to the police. One of the things that I always tell people, don't say anything to the police about it. You know, even if you think you didn't do it, even if you think you're not guilty, the more you try to blab about how not guilty you are, the police will start being more suspicious of you. It's best that you just be quiet.
Yeah.
Okay? But be polite, be polite with them, don't fight them, that sort of thing. And then what you do is that you can either apply for legal aid or just go through the first appearance through duty counsel and then apply for legal aid. Or if you know a lawyer, to contact that lawyer and see if they could take your case. There's many criminal counsels out there that are very good and very effective, very helpful for people. Okay? And as I said earlier, there are many cases that paralegals can even represent people in. Okay? The less serious summary type of offenses,
Yeah.
okay? Like mischief, common assault, trespassing by night, different things like that.
That's an odd one. Okay.
Yeah.
So if the police release you, they release you normally on what's called police bail, don't they?
Yeah. Yeah.
So basically, you walk away with a sheet of paper, and that sheet of paper on it will say, on the 14th of May 2024, you will have to appear before the judge in this and that and the other court.
Yeah, they'll give an address, a courtroom number, and what the charge is, all that stuff for you. So you have all that information. And they'll also give you information about seeking legal aid on that sheet of paper. Okay?
But what if you're denied police bail? You're not given this sheet of paper. Now what happens?
You get court bail.
So you're denied police
bail hearing.
Yeah, but does that mean that when do you get the next court hearing?
It has to be within a certain period of time. Before it was like within 24 hours, but sometimes it could be within 72 hours, okay, where they have it. But there are some times where people are held in pretrial detention for a long, long period of time. But that's because they've been denied bail initially for various reasons.
And some of those reasons may be that they're a flight risk, they're risk to the community, and a few other things. Serious, conditions where you are, for example, you would be denied bail typically if you refuse to show them ID, or you refuse to identify yourself.
Yep. Or if you try running away from the police, or try resisting arrest.
Like getting over the fence. Yeah, like that's going to happen.
Or if you can't identify a place where you live, okay? And this is one of the problems that homeless people sometimes have, okay?
Yeah.
Because you have to have a stable place to live until the time court happens.
Yeah.
Okay? Because they want to make sure that you're going to be able to show up at court.
Yeah.
Okay? If you don't have a stable place to live, what else can you do?
Yeah, third tent on the right, on the avenue past First Avenue is not going to cut it, is it?
Yeah, or the fourth tent in that encampment over there. Yeah. So I mean, this is where you have to be very, very there. And the other thing too is bail. Like if you're with the court bail, okay, this is where you actually have to go for a bail hearing before a JP. You actually have to show that you have ties to the community, you have ties with individuals within the community, and there may have to be a surety.
Okay, explain what a surety is. I was just going to talk about that.
Yeah. The surety is somebody who ensures that that person is going to follow the conditions of their bail and also to ensure that they show up at their court appearances.
Yeah. So
So, yeah,
basically, if I'm a surety for you, it likely means that I'm gonna have to actually have you live in my house.
yeah,
I'm gonna have to ensure that between certain hours, let's say between 8 p.m. and 8 a.m., that you are at home. And
mm,
I have to I'd have to agree to call the police if you were not at home during said hours.
yeah,
And that the, a wide range of conditions may apply, of course. Um,
absolutely. And
and
being a surety comes with some risks.
yeah,
People don't understand. I've had a friend of mine who was a surety for her son, and what happened was her son, I guess, skipped bail while he was under her surety, and then this guy got out, and then he later got caught. And then what they have is they have in a street hearing, they have a bail at a certain cost. You have to be able to pledge that certain amount of cost. Like if you're a homeowner or if you have enough money that could be backed up in the event that bail is jumped. Okay.
yeah.
So this what happened. She went to a street hearing and then she was charged $222,000. It was quite a serious offense that it was. Okay. So this is why the high amount of surety. Usually it's just a few thousand, couple of $1,000s or more.
But again, a lot of sureties, they're actually people are pledging their house on the surety because in fact, it's a bit, you can't pledge a car because they can't take a car because people need it for work and things like that. But with houses, they can take the house ultimately.
Yep, they could. Yeah. So be very, very careful if you are planning or wanting to become a surety. It's not a simple job, and you also have to make sure that you what know that person, and you have to explain to the person that you're being a surety for what your responsibilities are, and you have to ingrain in that person's head that you will take your responsibilities seriously. They
Yeah.
come home 1 minute after their curfew, that's it, you're on the phone. You have to be very, very. I was a surety before, so I know the seriousness of it. So these are things that people have to know the seriousness of this, because the court is entrusting you that you're going to make sure this person's going to come back and be heard,
So
and that
we
you're not going to jump bail.
Okay, so we've heard about the bail, about police bail. We've heard about court bail. So now, at a certain point, both of these are prior to you appearing in court for the first time.
Yeah.
So what happens when you appear in court for the first time, whether it's a summary offence or an indictable offence? What happens when you appear on the first occasion?
Generally, what happens is like the very first, there's an arraignment. There's you get materials coming by, like you get your first appearance, which basically talks about how they're going to try the case, how they're going to proceed. And then there's arrangements for disclosure. Most of the time, they're not bad with the disclosure on a summary side of it. For an indictable offense, it may take longer for the disclosure to come, and then there's certain things that could be requested back and forth. There could be meetings between the Crown and the Defense Counsel to discuss things. A lot of these things are decided outside of court where it doesn't come, but still the court supervises that process.
I can just obviously, if you've got like I don't know, let's say a minor criminal thing, the file was going to be maybe an an eighth of an inch thick, you know, a
Mhm,
few pages, a dozen pages, no, maybe not more, right?
mhm.
That includes all the evidence that they've got for this particular thing, maybe shoplifting or something like that. Maybe they have extra videos or something, DVD that they have for showing you doing it,
Yep.
right? But not a huge amount of material, you know, a thin amount of material. But again, if you're like a serial rapist or a serial killer or something like that, your amounts of material
Yeah, depends on the chart.
could be quite amounting, couldn't they?
Yeah. But you also have to be cognizant that it can only be about the charges that you're before the court on. If
Yeah,
you were before the court previously on other charges, they can't start including all those other charges other than under the system under priors.
yeah,
Because it's our Charter of Rights, that cannot be disclosed to anybody. Like, for example, if you're dealing with an indictable offense and then there's a jury, they can't be telling the jury, it says, oh, by the way, this guy raped 12 people before in the past. Hey, but now we're charging him with rape again. They can't be hearing that. Okay. Because
yeah.
every charge is as if nothing happened before. Nobody knows your past when they're hearing it. It's de novo. And then only when there's a sentencing happening, like
Oh,
say if you've been found guilty and then there's a sentencing, then they can consider your priors.
one other occasion where they can consider your priors. It's
What?
if you claim to be of good character.
Oh, oh, good character?
If you
Oh,
claim to be of good character, your priors can be brought into record.
well, one of the things too that could happen is if you are a defendant and you're insisting on taking a stand in your
Yeah,
defense, you might be asking for some issues to be asked of you, and you could be cross-examined on a number of things. So this is one of the things that you have to weigh heavily if you're going to decide to take the stand in your own defense. You don't have to. You don't have to. You
well,
don't even have to put
it's
up the
different.
defense.
It's different than me calling Angela and saying, Angela, you know the defendant. How many years have you known the defendant? Have you ever known him to do this crime, etc., etc.? And you answer those questions with no. As far as I'm aware, he's always been of good character. He's been always helped me. You know, the irony is that I remember some comments about some serial killers where they interviewed the next door neighbors, you know, with the mic around the thing, and the next door neighbors. Oh, he was always sweet as pie to me. Yeah, he's
The
just
other
killed
thing too you
25
have to be
people.
really careful of too is if the crown wants to bring something, like say if somebody who has been a sexual offender and he's claiming that he's never done anything like this before,
Yeah,
right? Like there is sometimes where there's similar fact evidence,
yeah,
but you have to be very, very careful in bringing that forward because a lot of times that's turned down because of charter rights again,
yeah,
right? Because this is theoretically the person could be a changed person and they stop raping people, okay? Like as if that's going to happen.
yeah. Don't be so assumptive. Anyway, yeah.
I know, I'm a cynic. I'm a cynic.
I know.
But this is what they do because they don't have like this also where they can bring that, and it could
Okay,
be it's, but it has to be asked, and it has to be done in what they call voir dire hearing, which is like a hearing within a hearing when you're making this motion.
yeah,
And it has to be just argued between the counsel, and then the judge makes that independent decision within that hearing. Okay,
yeah,
so very often they don't have, and if it's there's a jury, they don't argue that in front of a jury. So
yeah.
these are things that there's a whole lot of different things that are complicated because the reason it's complicated is to protect the rights of the accused.
And
And
okay,
so that
okay.
the
This
accused is not unjustly painted as a bad guy when in fact he might be totally innocent of the crime.
Yeah. And okay, so we're talking about what happens in court. We already talked a couple of about a month and a half ago about the other end of the court process when when the whole procedure has taken too long, and how that can be removed from court. So we're only introducing here about what happens in court from the beginning of the court case. So from first appearance, essentially.
So basically what happens is this becomes a supervised process. They want you to come back and they want you to make sure that progress is being made on the case. You get your disclosure. Sometimes there's more disclosure that you need. It's called the Stintcombe request for disclosure. There is a certain standard of disclosure you're all entitled to, and you're allowed to ask for a number of things from the Crown Attorney, and they go out and give it to you, because the Crown Attorney has to be completely transparent in terms of everything they have on you.
Yeah,
the defense doesn't have to disclose their cards otherwise, because you're allowed to. You do have to disclose your witnesses and some items about what you plan to appeal, particularly if there's a certain type of defense you intend to use. Okay, but in terms of everything else, probably not.
Yeah, in most crimes, there's not any certain types of defense, but in certain crimes, there are particular defenses that require advance warning to.
Yeah, like I'm going to use self-defense as a defense.
Yeah.
Okay? This guy came into my yard. I instinctively picked up my pistol, which is always in my pocket, and I shot the guy.
Yeah. Okay. Yeah. But we've been talking here really about the opening salvo of the court action.
Yeah.
And we'll leave it up to what happens in court is maybe another episode anyway.
Yeah.
Right.
Yeah.
Something we can talk about at a later time, or maybe you can look at with some other lawyers or legal professionals if you wish. Okay, Spin Legal, just to let you know, Spin Legal, it provides a discussion about legal topics on current interest each week. And we picked this week what happens if there's that dirty knock on the door and you're taken away by the police.
Yeah. And it always happens like at 3:00 in the morning or 8 a.m. or something like that.
No, it's deliberate at 3:00 in the morning. Didn't you know that the police get the next shift, or the day shift comes in at 3:00, and the night shift hasn't yet left at 3:00. So now we can go raid them.
You ever notice how the police knock on the door? They're always loud. When they knock on your door.
Yeah. And have ever noticed, if you've ever tried it yourself, that sharp knock? My golly, your knuckles hurt, don't they?
And I must give everybody the standard disclaimer about Spin Legal. We are not giving you legal advice. This is not a program where we provide legal advice. We give you information. So nothing you heard today amounts to legal advice. If you have a specific legal problem about this topic tonight that we discussed tonight, or any other topic that warrants any kind of legal discussion, please call a paralegal or a lawyer to have them assess your problem.
And so that everybody knows, you can call Invictus Legal, and the number's 905-688-5598. And one of our associates, or even Angela and myself, if you're lucky, may well be able to help you.
Absolutely. Absolutely. Right. I've been doing this for years within the summary court system. And there's many different things that go on in our courts. And it's very different. It's not what you see on TV.
Well, most TV, even Canadian TV, has this tendency to follow many of the American rules. I'm looking at it and thinking, that's not the rule it is in Canada.
In order.
And okay, the judge has got his wigs on and his bigger his purple gown or whatever, his gown on with the purple sash or red sash or whichever one it is. And hey, that's not the way it's supposed to be done in Canada. Yes, it might be
done very differently in Canada. This is one of the things that we might want to bring in a lawyer or legal professional who may want to discuss some of the standards or the etiquettes in these kind of courts, which is very interesting. I've always found it fascinating.
Oh, yeah. And of course, the one thing that is very Canadian courts are also different to the English courts. in this regard as well, because I've spent some of my earlier legal time in the English courts, and there's wigs. The barristers have wigs.
I thought you were wearing a wig, Peter.
I had my claws on a wig.
Oh, yes.
All right.
Okay.
But and the thing is that there's a lot more formality, for example, in the English courts, because, for example, if a barrister shows up even at a small claims hearing, they've got to wear their gown and wig.
Yep. The provincial courts, we don't have the lawyers don't have to wear our gown, okay? But in the Supreme Court, in the Superior Court of Justice and up, they do.
Yeah. Well, that would be an interesting topic to have for another time, and we like maybe a couple of lawyers could come on board with us.
Yeah, exactly. Yeah.
All right. Well, thank you, everybody, and thank you, Angela, for this. I think this has been a
fascinating. I've loved this topic. Love discussing this topic of law. And if any of you have a question or would like to hear discussion on a particular topic of law, or hear of a legal story that fascinated you or would be of interest that you would like to hear us discuss it, don't feel free to put the comment in the comments area below. Okay, and we'll be very happy to accommodate you. Okay.
Yeah, I'm just going to add our website. To the comments.
Yeah.
Which is https weareinvictus.legal, and there you go. It's in the in the comments.
Weareinvictus.legal.
Yeah, and it's been put in the comments in, and you can find us basically on Facebook at We Are Invictus. We Are Invictus. No, Invictus Legal LLP, isn't it, on Facebook?
Yeah. And Facebook is Invictus Legal LLP, which is our company's name. Or you can go to the web. It's www.weareinvictus.legal.
Yep, and there we are. There's the web page there, just for everybody's sake. And thank you, everybody. Thank you, Angela. And we'll see you all next week. Thank you. Bye.
Good. Thanks a lot. Bye-bye.